Hi, my name is Nora Hart. I'm a divorce attorney. I've been practicing for 15 years. We're in my office in Cold Spring, New York, where you can meet me anytime. Make an appointment on my website, heart-smart.net. One of the most common questions I'll get from people who come in for an initial consultation is, can I represent myself? And I will tell them that you have a right to represent yourself, and you can appear, it's called pro se, and that's Latin for in one's own behalf. And if you do appear in court without an attorney, you'll be considered pro se, and really you won't be given any special accommodation. You'll be expected to know the rules. You might hear that judges dislike pro se litigants, and that's because a pro se litigant doesn't have the knowledge. Basically, they'll make mistakes and they'll slow down the process, and judges really don't like that. And even a new or inexperienced attorney can be berated in open court. Certainly when I was new, I heard, I can't tell you how to practice law, counselor. I heard that plenty of times. But it is possible to represent yourself, and it's real work, it's time consuming, but as long as you're willing to do the work that an attorney would do and complete things on time and in conformance with the procedural rules, you can be an excellent advocate for yourself. And I genuinely think you're the best person to represent yourself, because you know the facts of your case better than anyone else, better than any judge, better than your own attorney, and you know where you can compromise on and what you just can't negotiate on better than anyone. So the other thing I will say, if you want to represent yourself, maybe you should arrange to check in with an experienced attorney. And I would love to help you if that interests you. I can tell you what to expect during each court appearance. Each one can be slightly different. I can tell you what documentation you need to produce and when. And I can tell you how to make an application to the court for things like interim spousal support or child support or attorney's fees. And down the line, if you're finding that your spouse is withholding evidence, I can help you with making a motion to compel discovery. And I, as an attorney, am prohibited from actually ghostwriting your work, but I can show you what a complete motion should look like and what the procedural rules are, and I can review anything that you draft. So I'd be happy to help you. I can tell you how to prepare for each particular court appearance, what you'll need to bring, what you should say, and maybe more importantly, what you should not say. And I want to emphasize also that the most difficult thing for pro se litigants, I find, is to keep their cool, essentially distinguish between facts and feelings, especially during court appearances, or really during any phase of litigation, but especially in front of a judge. Divorce is extremely psychological for anyone who's a party to the divorce, but to the court and to the attorneys, it's strictly logical. It's just a procession through the stages of litigation, basically. First, identifying the assets and debts. 2, classifying them as marital or separate property. 3, valuing them. And 4, dividing them. That's really all it's about. And it's hard for someone who's facing divorce to understand what's relevant and what's not. For example, early on in the process, you will submit a statement of net worth, and that in that you report your expenses and income, among other things. But for example, one of the questions is how much you spend on car insurance per month. Now, the court wants a dollar figure. They don't want to know that your insurance rate is unusually high because through no fault of your own, but because your spouse has 2 collisions that raised your rates. This type of thing doesn't matter, and it can be hard for litigants to know or to even accept that a lot of that just doesn't matter. And people come to court thinking that this or that they've gone through is unfair, and they can't wait to tell the judge about it. But really, most of what you think matters is irrelevant and will annoy the judge. Unless someone is truly, truly abusive in the relationship, and in order to allege that, you need hospital records, police records. But to have that kind of allegation taken seriously, you really need some supporting evidence, and don't bring it up if you don't have it, because that's just a red flag to the courts. So the court's not going to weigh in on things like, your spouse is a cheater, or they don't spend enough time with the kids, or they overspend, or they hoard. Doesn't really matter. You have a right to get a divorce. That's all the court can do for you in most cases. So your ability to represent yourself effectively, I'd say, depends largely on your ability to distinguish between the logical and the psychological. Okay? Anyway, if I can help you, please reach out to me. You can schedule a consultation on my website, heart-smart.net, or reach out to me any way you want. I'm located in Cold Spring, New York, but I can help you anywhere in the state of New York. Thank you.